case briefs, and so much more. LSData's got what you're looking for.
In 1977, the City of Bedford, Virginia, took legal action against James Leffel Co. over a contract dispute involving the design, manufacture, and installation of replacement turbines in a hydroelectric plant. After the initial installation, the turbines experienced significant issues, including deterioration and unsuccessful repair efforts. The defendant company had promised to resolve the turbine issues, leading the City of Bedford to delay litigation. However, a district court ruled that the city's claim against James Leffel Co. was barred by the Virginia Uniform Commercial Code's 4-year statute of limitations. This statute dictates that a breached contract must have a lawsuit filed within 4 years, and the clock begins ticking as soon as the breach occurs, regardless of whether the harmed party is aware of the breach. The case then moved to the Court of Appeals, where the previous summary judgment was overturned and the case was returned for further proceedings. The court held that the case needed to determine if equitable estoppel applied to toll the statute of limitations. Equitable estoppel prevents a party from using a delay caused by their own conduct as a defense in a lawsuit. In this instance, the defendant's promises and conduct may have misled the City of Bedford into believing the issue would be resolved without litigation, and the record did not conclusively refute the plaintiff's claim of reliance.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.